Thank you, Chairman. I'd like to know what is to stop a spouse from falsely accusing someone of something they didn't do, and then the person, the man, say, for example, becoming the victim and having his firearms taken away. What does the governor intend to do about that? Is she doing anything about that? How are you going to prevent that?
Certainly. So I believe that the proposed bill, and I'm referring now to 7688, I think there's several provisions in the bill right now to provide some protection. I believe that Representative Canario has already testified to some of those things, including the fact that it would be a violation of law to falsely make false allegations and swear falsely in a petition. And so that would expose a person to potential criminal liability. Additionally, because there is due process here, if a family member files a petition, if it is in the ordinary course of business, that petition will be heard within 21 days prior to any firearms being taken away from anyone, and the individuals would have the opportunity to testify, both the petitioner and the respondent, and the court could consider all of the evidence. Additionally, I believe that the proposed legislation includes language that requires the petitioner to list all court orders or any type of legal proceedings between the parties. And I believe that that language is probably aimed at informing the court as to whether there is a type of a contentious relationship, like a divorce proceeding or some such thing. So I believe that the proposed legislation does address that. And perhaps there are better ways to do it, and I'm sure that the House will continue to consider improvements.
Okay, so what would they do in a situation where there's never been an accusation at all, and just out of the blue, say that there's an argument, and the woman decides to call the police, make an accusation, and how do they find that to be? I mean, what do they do from there? What's the process?
Well, ma'am, I think that the proposed legislation does have fairly significant high standards before a judge can find probable cause, or let me rephrase that. Actually, that's incorrect. I think in order to remove a firearm from any person, a judge would have to find by clear and convincing evidence that certain factors have been met. And so I believe that you cannot simply make an accusation. The legislation states specifically that you have to make very specific allegations. Again, individuals have to testify under oath, and a judge will have to consider a whole host of factors, including prior threats, a pattern of threats, a pattern of previous violent acts, criminal history, prior protection, orders of protection, mental health history. There's a whole slew of factors that a court would have to consider before finding with clear and convincing evidence that the person poses a significant danger or risk of personal injury to another. And that is a pretty high standard. And I think all of that is there in order to guard against a frivolous or untruthful accusation.
Okay, so I guess what I don't understand here is if somebody makes an accusation and it seems like this bill, how would they have time to wait for a court to make a decision if they want to go and immediately take the firearm and remove any chance of harm?
Okay, so Representative, the way I read the proposed legislation, and again, I'm referring to House Bill 7688 right now, I believe that there are two separate processes in place. There is a process for an ex parte order, and that order would apply in cases where there is imminent danger, and under that process, an individual, or frankly, primarily law enforcement, or an assistant attorney general, could apply to the court ex parte, that means by themselves, for an order to remove firearms for a person. If the judge finds that there is probable cause to believe that the person poses an imminent danger of personal injury to themselves or to somebody else, the court could issue a warrant, as it would in many other situations where the court issues warrants to search or to arrest a place. That would allow law enforcement to proceed and go to the location where the respondent lives and search that place and seize firearms. That is one process, and that would require a judicial finding by probable cause, which is a constitutionally sound standard, prior to seizure of any property. The other method that is outlined in the bill is one where somebody makes a petition to the court and, again, lays forth all of the factors that the court should consider in finding that the person poses a significant risk of danger to another. However, before any property, any firearms are taken, the respondent is provided with notice, they're provided with an opportunity for a hearing, and it is only after that hearing, if the court finds by clear and convincing evidence, that the firearms would be removed or have to be surrendered.
Okay, that'll be it for now. Thank you.
Thank you.
Good evening, Chairperson Keeble and members of the House Judiciary Committee. My name is Susan Wynne. I'm a resident of Lincoln, and I'm employed in higher education. I'm the mother of 3 young adult sons and decided several years ago, after thoughtful consideration, that owning a firearm as a tool of self-protection was and is right for me personally. I'm also a board member of the Rhode Island Self-Defense Alliance, a volunteer organization whose sole purpose is to help preserve the right to defend our children and families from those who wish to do us harm. The lack of our government's ability to keep us out of harm's way is alarming. Recent failures to keep school children safe in Florida is a stark reminder that we must be proactive and prepared in our efforts to protect families. These failures reinforce the need for Americans to be armed for their protection. Clearly, we cannot depend on government to keep us safe. That is why the Rhode Island Self-Defense Alliance was formed. Limiting the right to defend ourselves is wrong and immoral. As a woman, as a mom, as a thoughtful citizen, it's my right to choose how I will empower myself and my loved ones. It's frightening to see legislation aimed at imposing greater restrictions on law-abiding, respectful Americans. I'm here today asking you to support me in my right to defend myself by defeating House Bills 7075, 7688, and 7763. We hear endlessly that this type of legislation is not going to restrict our Second Amendment rights or our ability to defend ourselves. However, based on the history of the words and actions of the gun control lobby, there is no doubt that stripping private citizens of their right to defend themselves with firearms is their ultimate goal, and we are tired of it. Thank you.
Thank you, Susan. Any questions? Thank you very much. Could we hear from David Fuller and Leanne Byrne on behalf of, I'm sorry, Representative Roberts, did you have a question? I'm sorry, I didn't see you over there.
That's okay. So I think what I hear you saying is that you feel safer as a woman to have some form of protection, correct?
Right, and that's my choice.
Okay, yes, and I agree with you on that, because I think, well, I commend you, first of all, for coming here and giving your testimony, because I think that many women feel that they need, you know, we don't have a chance as women against a man who's huge if they wish to do us harm, right? And at least with a firearm, it would even, you know what I mean? It would level the playing field and give us at least a shot at survival if we need to fight to defend our lives and our own
Especially
homes.
if we're trained.
Yes, of course. Yes, I think that's so important. Thank you. Thank you for coming here and giving your testimony.
Thank you.
I'm Latasha Davis, and I'm from Exeter. I appreciate the opportunity to testify tonight. I'm here to oppose all 3 of these bills. I won't get into the technical details of bump stocks and the mechanics of it, but the fact of the matter is no gun got up by itself and killed somebody. Guns are not violent, people are violent, which I'll address on the other two bills. When I walked into the building tonight, I walked through a restricted access. I went through a metal detector, and their police are all there. We know how to defend buildings. We know how to do it. How can we say that our schools should be free of defense? Because that's essentially what we're saying. If we don't have the metal detectors, if we don't have the hardened buildings, and if we don't have the defense there. When I look at the circumstances that I've heard about the shooting in Florida, I look at the whole circumstances as the complete argument for concealed carry and self-defense, because at every single level, the government failed to protect those children. The FBI failed. The police failed. The police didn't go inside. Apparently, some of the windows were hurricane windows, and so that created some difficulty for him shooting out of them. But one thing could have stopped that shooting there, and I guess it was one of the coaches and teachers there, who blocked bullets with his body. And I remember that from several years ago when we were all up here testifying after Sandy Hook, that the principal had blocked bullets with her body. Now, what if that person had had a firearm? They could have stopped the shooting right there. And frankly, I am so angry and outraged that the response to every one of these shootings is, we have to take away more guns, we have to do all these other things that infringe on the rights of law-abiding citizens. But it doesn't solve the problem. It doesn't defend the students, in the schools. They're defenseless. We advertise gun-free zones. Perhaps the reason we haven't had a school shooting in Rhode Island is because concealed carry permit holders are allowed in there right now. And I understand that there are, bills trying to stop that. But maybe that's a reason. Somebody might not want to go there. It's a disincentive for somebody to go and attack in a school. So I think the best thing is defense, and that comes from the individual person, and I believe in our personal freedoms. And if we decide that we can throw due process aside in this case, because this case is special, as we did last year with a domestic violence bill, we can just take the guns away and we'll worry about working it out later. Well, then you're essentially throwing out due process. It doesn't mean anything anymore because, well, this time we're not going to, hold to it. And it's a very slippery slope. In all of this discussion, nobody talks about what a defense guns are. Now, I've testified before this committee before and last year. I'm here and able to testify because somebody protected me with a gun. I know last year, 3 members of this committee testified that they had been protected with a gun. I don't know if it was by themselves or somebody with them. Guns are a defense, and anything that is going to infringe upon that right to defense, I am totally opposed to. On the issue of mental health, I don't know how we get around privacy laws. I don't know how to handle that, because if somebody hasn't done anything bad, to me, it's wrong to take away their property. I have read that in Florida that there is a law that says if you threaten somebody, they can arrest you. And that this kid down in Florida, the shooter, had threatened, but nobody had arrested him. And apparently it's tied in with a whole lot of other things in terms of reporting and funding and grants, and I don't know the details of it. But to me, having a good defense in schools is the first thing. And who has more incentive to protect the children than people who are already in the school? Again, we have the example, police did not go into the school in Florida. They staged outside. They're coming from outside, from a relatively safe place, into a place of danger. So you have to be pretty courageous to do that. But the people that are already inside, the adults that are in there, they're there already. They have the ultimate incentive to protect and defend themselves and the students, and they ought to be allowed to do that. And added to that, I would say, I think that, parents who have concealed carry permits ought to be able to go on school grounds with no restraint and at functions, because it's a protection for the students. So I am opposed to all of these bills in principle. I think we can't just throw due process out the window in cases that we want to. And we need to stop going after and banning inanimate objects, unless people want to ban trucks too, because you can kill with trucks, and all sorts of things. So I appreciate the opportunity to speak, and please oppose these bills.
Thank you, Latasha. Any questions? Representative Roberts.
Thank you. Thank you for your testimony. Are you suggesting that maybe we are addressing the wrong issue here? Because it sounds to me like what you're saying is that we need to address school security. For example, we see at the State House where we are armed at the State House, our security here. Everybody knows they're going to be safe here. It's guaranteed safety. We should probably, I'm thinking personally, we should probably have some kind of security put in for our children. Of course, what that is, I'm not sure exactly yet, but there are options, and I think personally that we should explore other options before we just so readily go and attempt to infringe on people's rights to keep and bear arms. And that's what it sounds like I heard you saying. Is that correct?
Yes, it is, because we obviously do know how to defend buildings and structures.
Yes.
We know how to do that. We're doing it all over the place. So why not in schools? But I think adding the concealed carry, and allowing people, as they can now, to do that in schools is an additional protection.
Yes. Yes, and guns, rather than think of them as a weapon, because of course who really wants to use them as a weapon, but they are, it seems like it would be a great way to shield oneself from harm. So I have to agree with you on that, and I thank you for your testimony.